The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. And welcome. And I'll especially welcome the students from the University of Iowa Law School, Professor Wright students. I'm glad you're here this morning. There are 7 cases that will be submitted this morning. Those cases are Lowe's Home Center versus Iowa Department of Revenue, Jason Blume versus DJs, Inc., Iowa Supreme Court Attorney Disciplinary Board versus Michael Jacobsma, Iowa Attorney Disciplinary Board versus Derek Morin, Iowa Attorney Disciplinary Board versus Lonnie Saunders, State of Iowa versus Anthony Harris, and in re the interest of M.D. Those last 5 cases are now submitted to the court without argument, and we'll proceed to hear the arguments in Lowe's Home Centers. Mr. Smith.
Good morning, Your Honors. Kendrick Smith representing Lowe's Home Center. And I would hope that you all are familiar with Lowe's. It is a major retailer of home improvement merchandise, but it also sells installed home improvements to customers' homes. And those 2 transactions have completely different sales tax consequences under Iowa law and the law of every other state that is a member of the Streamlined Sales Tax Agreement. A sale of tangible personal property is subject to sales tax. The customer pays it when he buys his hammer. A sale of real property improvement is not. The construction contractor, in this case Lowe's, is deemed the final user and consumer of the tangible personal property that's affixed into the customer's home, and he is assessed use tax on the cost of the goods that are pulled out of inventory and put into the home. In this case, Lowe's paid that tax. There's no issue on that point. The issue is the Department of Revenue claims that the customers separately owe sales tax on the labor used to install these permanent home improvements. Since that's contrary to how we read the statute, and particularly how the regulations interpret the statutes, it was not collected by Lowe's and they've now been assessed. There are 2 legal issues that we believe that are before you. The first is whether incidental labor related to the installation of a permanent home improvement is subject to tax under Iowa Code Section 423.2, parentheses 2, which I'll call the Services Tax Act. It's the 66 enumerated services that are subject to sales tax. And if so, are they nevertheless excluded from tax under Iowa Code Section 423.337 as services on or connected with new construction, reconstruction, alteration, expansion, remodeling, or the services of a general building contractor, architect, or engineer. Now, read together, and particularly read in conjunction with Regulation 219 promulgated to interpret these very statutes, there are 4 principles. 1, unless a service is specifically enumerated in the Services Tax Act, it's not subject to tax. Number 2,
Stopping you there, carpentry, pipe fitting, electrical, those are enumerated.
Those are enumerated.
Okay.
Number 2,
go ahead.
Enumerated services are subject to tax, meaning the customer pays for the service if they involve repairs or if they involve installations of items that once installed remain tangible personal property.
Is the repair issue out of the case now in view of the director's final decision?
The repair issue is central to the case, Your Honor. I think the repair, the choice, what the regulations tell you, what the ALJ told us, what the department has been arguing up and down the line, and what the statutes provide is it's a binary choice. It is a bright line choice. It is either repairs, if it's dealing with a structure or a building, or it's a capital improvement or what's referred to as construction, reconstruction, alteration, expansion. It is either taxable as a repair or it is not.
What about installing or installation labor services? Aren't those something different? You can install something that's not a repair and doesn't reach the scale of new construction. Am I wrong?
You are wrong, Your Honor, in that the bright line is that the installation is taxable if the final result remains tangible personal property. And the regulations are very clear on that. I'll go over them in a minute. If it becomes a permanent capital improvement, it is affixed to and becomes part of the real property, it is not subject to tax. That
Is the term capital improvement in the code or regulations?
Capital improvement is defined throughout the regulations as to what repairs versus a capital improvement. They tell you what the distinction is. It is the ALJ's ruling, which was adopted by the director with that one change saying they weren't repairs, that said, that's your choice. It's a bright line choice, repair or capital improvement.
As I understand it, what we're talking about as a practical matter are appliances that are being replaced. And I mean, normally when I replaced one of my appliances, I wouldn't consider that a capital improvement, right?
I believe the Internal Revenue Code would, and I believe, in fact, regulation, I'll give you the specific regulation. 219.11, 219.9 and 219.11 that distinguish between construction contracts and installations of machinery and equipment which remain tangible personal property after the installation. So you're correct. If I install a refrigerator and it's portable, that installation is part of the real property, a tangible personal property sale. That's taxable.
Let's say I bought one of these appliances at Lowe's, and I didn't get the package deal that includes the installation. I just got the appliance, and I then went out and paid my regular handyman that I work out with at the YMCA to install it and do any carpentry work to get it to fit in and all that sort of thing. Wouldn't I have to pay tax on his bill?
On his bill? I believe under the regulation you would not if it becomes a installed capital improvement. It becomes part of the real property. And I think where the distinction could be, and that's a very good question, is if you look at what is called the predominant service rule, which is we've talked about, both sides have talked about. That is, it's codified in the regulations at 701-26.1, parentheses 2. And essentially what it deals with when you have taxable and non-taxable services performed as one transaction that's lump sum. And so you look at what's the predominant service. So in each of these cases, it is undisputed that these were construction contracts. The customers were not buying a repair of something. They were buying an installed home improvement of a new, better, improved item. And the predominant service rule provides that if the predominant service is non-taxable, in this case a sale of a real property improvement, then any incidental plumbing, electrical, carpentry work is also not subject to tax because that's not what the customer is buying. The customer is buying an installed dishwasher. And we cite repeatedly to the Tax Review Committee's decision on this point, which appears in page 353 to 356 in the appendix, volume 2, that addressed this exact issue back in 1976, and it's never been changed or modified, dealt with the installation of air conditioning unit. And the question was, okay, that we paid the tax on the tangible personal property, but are the enumerated services that involve carpentry and plumbing and electrical work, is that also subject to tax? And they said no, the enumerated services were incidental to the overall installation of an air conditioning equipment. And they went on, it has been the department's position that where a named service is incidental to a service not specifically enumerated, such as the installation of a real property improvement, the entire service is not subject to tax. So in the case of your question, your guy from the YMCA who's a repairman, an installer guy, you are buying from him an installation service. So that may be separately subject to tax. But what we're dealing with here is a lump sum construction contract. Doesn't break it out. You pay one price and you get an installed item. And in that case, the predominant service is the installed capital improvement.
Doesn't that give kind of Lowe's a competitive advantage?
Not if everyone else does this too. I mean, this is what the law says. This is what the statute provides.
You say it with such confidence that you install that refrigerator that Justice Mansfield was talking about, and that's a capital improvement. I'm having a hard time getting my head around that. So if I sell my house, that fridge is going to automatically go with it, because it seems to me that usually appliances are not part of the property, which would be a non-capital improvement.
Well, the items we're talking about here would be garbage disposals and
I'm talking about the example Justice Mansfield gave.
I think if it's built-in and you put like, it's attached to and has wood around it and it's become part of the house, yes, it would go with the house. You'd be damaging the house to take it out. Similar with a dishwasher or a garbage disposal. If you're buying the house and it has a dishwasher there, you're expecting that dishwasher to go with the house. Or the garbage disposal. If someone removes it, they're damaging the house. They're making it worth less than what it was that you were trying to buy. And the best definition, which is what, by the way, all the streamlined sales tax states do, save Iowa, is they follow what is the IRS regulations. If it is installed, if it is if you put a window in your house, you can't deduct that as a repair. You have to add that to the basis of your house and you capitalize it. That's a clear, bright line distinction, and really the only way to implement this law. If you look at what the director says, she made up this third category of installations that result in capital improvements, but they're still subject to tax, but they're not large enough in scope or scale. What does that mean? You know, are 2 windows enough or 3 windows enough? There's no way to distinguish what is taxable and what's not. It's impossible to implement that rule.
So if I go to Lowe's and pay to have a new ceiling fan installed in an existing room in my house, and that's all I'm doing, in your view, that's not taxable?
That is correct, Your Honor. And I even have a regulation that addresses specifically that, which is, again, 219.11. It has 2 lists of items, non-exclusive lists. One is taxable installations that remain tangible personal property, and the other is non-taxable installations that become part of the real estate. And
Mr. Smith,
Yes, sir.
wouldn't Lowe's have a competitive advantage in that situation vis-a-vis the electrician that you would otherwise hire to come and install the ceiling fan that you purchased at Lowe's?
If an electrician enters into a construction contract and the electrician is the one who goes and gets the tangible personal property and installs it, he's treated precisely the same way.
No, I'm talking about if I go to Lowe's and buy a fan and bring it home, and then I call up the electrician and say, could you install my fan? And they install it. Would Lowe's have a competitive advantage under that situation?
I think that's 2 different services here. Lowe's is selling the installed item. The repairman is only doing an installation of a specific item. The way I would read the particularly 219.11, if the installation results in a capital improvement, I'm not sure that would be subject to tax, even if it's just by the repairman. What you go on is you got to read 219 in its totality. It gives example after example after example of this binary bright line distinction.
Well, aren't taxes imposed on carpentry, plumbing, and electricity?
Repairs, yes, sir. If there's something, if my window is defective and I have a carpenter come in and fix it,
Well,
then that's subject to
repairs and installation.
Well, carpentry, under the regulation that it defines carpentry, specifically defines it as repairs. So no, if a carpenter comes in and installs something, it's not a repair. That's not subject to tax under the regulation interpreting what a carpentry is.
I may agree with you on that, but then the regs and the statute itself, in the case of the electrical items, refer to installing. So,
It does. It
so are
does.
you in a weaker position on installing?
Well, that's why you have to read 219 in its totality. I think you have to try to find some consistent way to read it together. You are correct, that is different from the plumbing and from the carpentry, and they do talk about installations. but
Is Lowe's challenging the validity of any of the regulations, or rather only that they're being misapplied here?
Only that they're misapplied. Obviously, if a regulation is promulgated, the Department of Revenue has authority to do that. They cannot misapply their own regulations, and that's what we're challenging.
You reviewing that as the application of law to fact, do they get do we give some deference to the department's application of their rules to this factual record?
I think there's no dispute on the facts, so I don't think there's a problem on if you defer to what their interpretation of facts. I think the ALJ did a pretty good job of summarizing the facts. As to the law, what you cannot give them, you cannot, in the basis of interpretation, expand, enlarge, change the status of what the statute says. You can follow the regulations, but I think their interpretation of their regulation, particularly if the regulation says something different from how they're interpreting it, I don't think they're entitled to any deference in that. And we cite the case, the AOL case, AOL versus Iowa Department of Revenue, that when an agency elects to be its own lexicographer, persons are entitled to rely upon the established definitions. And that's what Lowe's has done here. It has relied upon specifically, there are two explicit areas in the law, which I'll have to talk about, I guess, on rebuttal here.
Mr. Smith, thank you.
Thank you.
Mr. Chaprazov.
May it please the court. Good morning. My name is Hristo Chaprazov. I'm an Assistant Attorney General and I represent the Department of Revenue in this appeal. The standard of review in this case is not de novo. The issue is not the department's interpretation of its own rules. One of the issues in this case is indeed the department's interpretation of the relevant law as stated in its rules. But even if the issue were the department's interpretation of its own rules under AOL, the standard of review is not de novo. In fact, this court explicitly declined to address and resolve that issue in AOL. And as for the standard of review with respect to the department's interpretations, if you apply the Renda framework and we look at the analysis that this court has done since Renda, you look at the language of the statute. You look at whether the agency has rulemaking authority. You look at whether the agency has expertise.
Here's where I see this. I mean, I don't think the standard review, at least in my view, is all that complicated. They've conceded you have authority to issue the rules and that they would have the force of law. You say the same thing. So we're dealing with what the rules say. When we come to the interpretation of the rules, it does strike me that the taxpayer out there is entitled to rely on the language of the rules. And if there's some other gloss you want to put on the rules, then you need to put it in the rules. And so in my view, we're kind of reviewing the rules de novo. And am I wrong about that?
I don't think, first of all, I think where both sides disagree is not with respect to what the rules say. We just disagree as to the conclusions once we apply the rules to the facts. But if you're asking whether the department or any other agency should have discretion in interpreting its own rules, and to be fair, in this case, I don't think the department has done anything but an application of the plain language of the rules to the facts of the case. But if the issue were the department's interpretation of its rules, I think an agency should be given deference, assuming the language of the rules is not clear in some respect. The agency, I think, should be given deference so long as its interpretation is not erroneous. If it's, if it's plainly erroneous, if it's inconsistent with the language of the rule, I don't think there should be any deference. Turning to the first issue, the merits of the first issue in this appeal, whether the installations involve a taxable labor. This is what the agency did. It applied the installation instructions contained within the installation manuals for all the items involved in this case to the description of the enumerated services of plumbing, electrical installation, and carpentry. And so once that application was done, the agency concluded that the installation instructions clearly fit within the scope of these enumerated services. The district court did the same analysis on judicial review and came to the same conclusion. That's why it affirmed the agency. And Lowe's is not really challenging that part of the district court's decision. Lowe's instead raises two other arguments, saying that what we have here is not carpentry or electrical installation or plumbing. What we have instead is this service of installing capital improvements. First of all, the service of installing capital improvements, I think, is just a restatement, really, of Lowe's argument that the installation should be exempt under the exemption provision. And I'll talk about that issue in a moment, but I don't think there is a service of installing capital improvements. You cannot bypass the enumerated services statute by saying, I'm not doing plumbing, I'm doing the installation of a plumbing fixture, I'm installing a kitchen faucet. It's not enough to name
Counsel,
the service.
but the carpentry definition is limited to repairs. So if it's an installation that does not involve a repair, is that taxable?
Yes, and the rules in Chapter 219 make clear that repairs and installation work, if they involve an enumerated service and if they're not otherwise exempt because they're connected to some kind of a remodel, for instance, they're both taxable. And I understand, Your Honor, that the carpentry rule has the word repair in it, but it also talks about carpentry being defined as what we generally understand the business of a carpenter to be. And also this this regulatory definition was clarified in some agency precedent back from the early 2000s, 2002, I believe. So I think even as to carpentry, it's not just repairs, it's installation work that's taxable as well. And on the issue of capital improvement, before I move on, we don't have any evidence in the record to decide whether any of these installations resulted in a capital improvement, because capital improvement is defined as something that materially adds to the value of the house in this case, or substantially prolongs its useful life. And again, I don't think we have any evidence to make that determination. Moreover, as to whether this installation of capital improvements is the predominant service, we likewise have no evidence in the record to decide whether any of these installations involved more than one enumerated service, and assuming they did, we don't know which one was the predominant service because Lowe's didn't put any evidence in the record on that issue.
What about their argument that under 219.11, all they have to show basically is that the item, the appliance, once it's installed, becomes a permanent attachment to the property, and you would damage the property, the real property, if you pulled it out again? What about that argument?
Well, first of all, factually, I disagree. I think most homeowners have replaced at one point or another a dishwasher, and I don't think the house was damaged. So as a factual matter, I disagree with that. But the point of Rule 219.11 and also to an extent 219.12 is to look at the tax on the materials charge. So what that rule is designed to explain is what types of installation work is something that normally becomes a part of the structure, part of the house, and if so, that is something that could be part of a construction contract. But we don't have construction contracts in this case. What we have is a homeowner walking into a Lowe store and buying a replacement fixture or a replacement built-in appliance, and there's been no evidence in the record that any of those installations were somehow on or related with a bigger installation, a bigger remodel or a bigger or a new construction, for instance. What we have instead is just the evidence that this is the extent of the installation work that was done in all of these cases. And so Rule 219.11 again, just deals with the tax on the materials charge, which is actually not an issue in this case. And you know, even if that issue is accounted for, in this case, Lowe's is not absolved of its responsibility to account for the tax treatment as to the installation labor. That is something that also has to be accounted for. Those rules, when you, and I agree with Mr. Smith, you have to read the entire Chapter 219, and when you read the entire Chapter 219 and try to make sense of all of it, read it in a comprehensive way so that all of its parts make sense, you don't come to the conclusion that Lowe's is putting forth in this case, because the exemption provision is not written in a way that it exempts the installation of fixtures or installation of capital improvements. Rather, you have to show that whatever enumerated labor is involved, it rises to the level of new construction, reconstruction, alteration, expansion, or remodeling. And again, there's been no evidence put forth by Lowe's on this issue at all. The only evidence that Lowe's did include in the record is a statement in one of the affidavits executed by Lowe's tax manager, Mr. Craig Price. And that statement, to paraphrase, amounts to the following: I believe that all of these installations were meant to be on or connected with a remodel or an alteration. In other words, it just parrots the statutory language, but the problem is it's not a statement of fact. It's not enough for Lowe's to shoulder its burden of proof on the exemption issue. It's nothing more than Mr. Price's opinion as to what the legal conclusion should be on that issue. And again, as I said, that's not enough to carry the burden of proof.
Is the repair issue out of the case in view of the director's modification of the ALJ's proposed decision?
I believe so, in the sense that, so what the director did is she affirmed the ALJ and the repair issue comes under the first issue. And so the director affirmed the ALJ, but she used the opportunity to clarify the meaning of repair as it relates to these installations. And she rightfully pointed out that whether these were repairs, and I believe she said there is no evidence in the record to decide that they were repairs, whether they were repairs or installation work, it's really beside the point, because all we have to decide here is whether they're taxable. And she said they are taxable either way. And even if there is no evidence as to the condition of the item that was being replaced, what we do know is that in all those cases it was a replacement of something that was already there. And so it's an installation work. It's taxable because it involves enumerated services, and then we move on to the exemption issue.
So where's the line drawn between a taxable installation service and new construction installation that's not taxable?
Well, so the textbook example of a new construction would be you're building a house, and so you're contracting with all the necessary parties, and the builder agrees to provide all the materials, all the labor, all the equipment that's necessary, all the supplies, and to erect those on the property that you own. And so in that regard, everything that takes place, any plumbing work, any electrical work, any installation work, that is, of course, something that would not be taxable. And actually, to address a point on the repair issue, the statutory history in this, with respect to the relevant law here, demonstrates that not only repairs are taxable under Iowa law, because there would be no need for the exemption. These services became taxable in 1967, and 2 years later, the exemption that we're dealing with in this case was put in place because the legislature realized that every time a house gets built, every time some structure comes into existence, there would be tax on the enumerated services involved.
You know, it would be the line, say, between if I have my whole kitchen remodeled versus if I buy a new refrigerator and I have to modify the space for that refrigerator. Would that be an example of where the line is drawn?
Yes, if you remodel your kitchen, if you replace your, for instance, kitchen cabinets, perhaps you put down new floor, maybe as part of all that, you replace your kitchen countertop. That is no question a kitchen remodel. That would be all the installation labor. If it's enumerated services, that would all be exempt. But again, what's at issue in this case is nothing that even comes close to the hypothetical Your Honor just presented, because, and really, the terms of Lowe's contracts themselves, they make that clear. What's written outside the scope of the installation work is any type of structural change, any type of so Lowe's is not, as part of these installation works, they're not introducing new electrical circuits, they're not introducing new plumbing lines, they're not modifying existing lines, they're not modifying your cabinets if the dishwasher happens to not fit in. So we don't have anything but removal of the old item and replacement of that item with something new. That is the extent of the installations we have in this case.
So if all I'm doing is replacing my garbage disposal, the department's position is I pay sales, or that sales tax is due on the labor for that installation.
That's correct. If that's the extent of what you're doing, yes.
Is Lowe's a general contractor within the meaning of the exemption?
I don't believe so. And a couple things on the general contractor issue. First, there's been no finding in the agency that Lowe's acted as a general contractor on any of these installations. In fact, the ALJ declined to address the question because it wasn't necessary, because the exemption provision deals with the services of the general building contractor, and as the ALJ pointed out and the director adopted that conclusion, the charges in this case are not dealing with general contracting services, they're dealing with installation labor. And even if you have a general contractor, a bona fide general contractor, who for whatever reason decides to come in and install your dishwasher without anything additional, that would still be taxable. The exemption is not hinged upon who does the work, but the nature of the work. That's why the general contracting issue never really became central to the exemption provision. But to be fair, there's never been any finding in the agency, whether by the director or the ALJ, that Lowe's acted as a general contractor.
Hypothetically, if we were to determine carpentry services are not taxable unless they're a repair, would that require a remand for recalculation? Would it be difficult to exclude carpentry from the other installation services involving electrical or plumbing work?
I suppose the honest answer is that I don't know, because carpentry, some of the items installed perhaps involved 100% the service of carpentry. Some other services,
Doors and
perhaps,
windows.
correct, and some other services, sometimes even the installation of a dishwasher could involve some type of carpentry. But again, to emphasize an earlier point I made, simply because the definition of carpentry includes the term repair, I don't believe that language was ever intended to encompass only repairs, because you have to read it in connection with the rest of Chapter 219. Thank you very much.
Thank you as well. Mr. Smith, you may present your rebuttal.
Your Honor, I promised you that, as I was sitting down, that there are regulations that explicitly address this. I'd like to direct the court to two, which remarkably the Department of Revenue pretends doesn't exist, and it has never been addressed. One is Regulation 219.4 that specifically addresses contractors, subcontractors, or builders who are retailers, this situation. And it says there are three things they can do, and only three things. A sale by a contractor, retailer of building materials, supplies, and equipment which does not provide for installation of the merchandise sold is considered a retail sale and subject to sales tax. Fine. Conversely, a sale by a contractor, retailer of building supplies, materials, and equipment which provides for installation of the merchandise is considered a construction contract, and tax shall be paid by the contractor, retailer based upon the cost of materials at the time the materials are withdrawn from inventory for use in a construction contract performed in Iowa.
Now, the department says that only applies to the tax on the materials, but that doesn't address the question of installation labor services.
Which I will get to, but what that does say is that it is a construction contract. Under the rules, it is a construction contract, and Lowe's was taxed as a construction contractor, not as a repair service.
Do you get permits when needed?
Yes. Lowe's has a general building contractor license in Iowa. They get all the permits. They get everything that they require to do to make sure that it is legal. It's in
I mean, for individual jobs. You go to small towns and install something. Do you ensure that community doesn't have some type of an ordinance that requires a permit for that level of a purchase?
The contract requires all necessary permits. So as Lowe's, as the general contractor, has to get all necessary permits. That's part of their obligation.
But then the language goes on the next sentence, as I read it, is, then it goes on and says, when a contractor retailer does repair work, the contractor retailer is acting as a retailer and not a contractor and must collect tax on the sales price charged for the materials used for the repair and on the sales price charged for any labor used in the repair. Now, I think repair here is a kind of a, as I read it in the regulations, is kind of a term of art. It means if you have to do a little bit of wiring to hook up the new ceiling fan, that's a repair.
Read what that just said, though. If it's a repair, the customer pays everything. The customer pays the tax on the materials and on the service. This clearly was not a repair because it's a construction contract. They taxed Lowe's as a contractor. There are only three things that a contractor retailer can do. It's a sale of tangible personal property, a construction contract, or a repair. And only one person owes a tax on each of those transactions. If it's a repair, the customer owes all the money. That isn't how they taxed us. They taxed us as a construction contractor. And that's why they won't address this regulation. It addresses precisely the situation. The second one is the Iowa Contractor Guide, which, again, they refuse to acknowledge exists. It's in volume 2 at 337, which states, I don't know how it can be clearer, a contractor retailer performing a construction contract does not collect sales tax from the final customer. A contractor retailer performing a taxable sale, parentheses, repairs, must charge his customer sales tax on the labor and materials. There is nothing in the law that allows them to bifurcate this lump sum contract into two separately taxable transactions to two different people. It's not in the law. They cannot show you anywhere in the law that that's authorized. And that's our point. We were contractor retailers following exactly what this rule says. And they may not like it. Maybe they should go to the legislature and change the law, but that is what the regulations say. That is what we followed. The argument that was made to the director is it is a bright line choice. And the quote, I'll just give a quick quote before I sit down because it's important. I ask you to read the brief that the department filed in response to our protest. If the department believed that the installations under protest amounted to more than repairs to the structures where the installations were performed, the assessment would never have been issued or would have been canceled. Again, if it's a capital improvement, look at what the contracts say. There's not a contract to repair anything. It is to install a new capital improvement into the real property. Thank you, Your Honors.
Mr. Smith, thank you as well. The case of Lowe's Home Center versus Iowa Department of Revenue is now then submitted, and we'll next hear the arguments in Blumel.